The problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's saying there is a constitutional process by which it can be done under 371.
No, you can't do away with 370 sub-clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the Constitution in force.
Right.
Can you not say that another order be issued that it can, under one, saying that all the provisions of the Constitution apply, and list them, all of them, and say all of them apply?
You know, the problem there is, if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
Mr. Sibal,
it doesn't apply to the other parts.
Insofar as clause D is concerned,
yes,
there are no limitations. If you read it, much of the provisions of the Constitution shall apply in relation to the state subject to such exceptions and modifications as the precedent by order specify.
Correct.
This is done by second proviso.
Correct.
Provided further that no such which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government.
Yes.
The treaty of accession, defense, and commerce.
That's correct. That's correct. And the lists involved there.
And the list involved.
Correct.
So suppose if the Parliament decides to make the entire provisions of the Constitution applicable to Jammu and Kashmir, limitation under clause D.
Yes, there is. That's the point I'm making, Malad. Because the structure of 370 and in the context of the legislature of Jammu and Kashmir is that the residuary power remains with the state.
Because the distinction is that insofar as those
concurrent list and instrument of accession are two separate things, but there's no issue there. They can do it. Both under 371, no issue.
Insofar as instrument of succession, those
only 4 items.
Their only requirement is consultation.
That's correct.
Insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, Mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process, even under 370 sub-article 1. That's the problem. But I see the point that your Lord is making, my Lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my Lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement, the philosophy of basic structure.
All right, let's not talk of 2023, Madhas. In 1950, what was the position? This was the position, that it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament, how can we say that Parliament could not have exercised its plenary amending power?
This is not basic.
To abrogate Article 370.
This is not basic structure, Madhas. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact. Unlike other states where Junagadh, he didn't agree. You know, as a political act, you took over Junagadh. He ran away, the Maharaja ran away.
But that, Mr. Sibal, there, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden.
That's all right, Mala. So then we could...
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Mala. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes, that's right. That's the procedure.
That we've appreciated that. Yes, of course we have appreciated that.
We are limited only on that.
That the process, in other words, your contention is that the process which the Government of India followed assumes that the proviso to clause 3 apply, that this change has to be brought in through a Constituent Assembly.
Correct.
But this was evidently not the Constituent Assembly, because A, it was the Legislative Assembly that you have invoked, and 2, even that Legislative Assembly was dissolved and ultimately Parliament was exercising that power in the 356.
Now the larger question, supposing your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the constitution, if they follow them, maybe, but that may be valid, may not be valid, but I can't answer that question in a vacuum. But my lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various princely states and...
Mullah, those pacts were there, recognition granted to rulers, but Mullah, either they completely assimilated themselves into the union and be part of a state, or they were taken over. Either Hyderabad or Junagadh.
On the basis of certain agreements between the states and the princely
states. Correct, but those agreements were different from this agreement. Mullah, your lordship is right. If it were that kind of agreement, then your lordships would apply those standards and those principles and those judicial dictums which your lordships applied. Why not on that?
Here your argument is that unless the views of the entire populace of the Jammu and Kashmir are taken into consideration, the abrogation of 370 can't be
yes, that can be done. But that's
then the negotiations were not between the elected body, the negotiations between the princely state and the union.
Correct. And that was accepted. That very thing was accepted by the then constitution makers. So, whereas we can't go into...
So if what was accepted, insofar as the other states are concerned, it could be taken away by 363A.
Correct, but that was not the position as far as Jammu and Kashmir is concerned. I'm not saying anything. I agree with what my lord is putting to me. But how do you change the constitutional structure? There must be some power. You can say that you can do a political act. Today you say, look, forget about all this. We take over Jammu and Kashmir. Fine.
363A was done under 368.
Yes, you can do that. But point today is, that's not an issue before you. You're not going to answer an issue which is not, with respect, the greatest respect, which is not before you. You're not going to find a power for them which doesn't exist and which is not followed. I understand, Mullah, the difficulty, and I understand, Mullah, the fact that at some stage or the other, this had to be, let's put it this way, this had to be done. Let's put it this way, somebody said this has to be done. But then Mullah, there must be found a constitutional way of doing it. I'm not saying there are...
What has to be done, I would say, but whether it could be done or not.
No, not could
mean the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the process by which they followed was...
Yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly. Yeah. Absent a Constituent Assembly, you cannot exercise the power to abrogate.
Number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believed that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
You're the Parliament.
I'm not saying anything.
212.
Yeah, so I'm just saying, 11 o'clock, nobody knows. Nobody knows.
Larger issue as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates. And the fact of the matter is, Manoj, apropos what my learned friend said, almost all the laws applicable in the Union of India were applicable in Jammu. As of today, Manoj, I have a list, it runs into, pages after pages. Everything has been adopted, apart from other than the residuary power. Everything is adopted. And remember this, if you use 368, you will have to have 2/3 present and voting. So you don't use 368 because you don't get 2/3 present and voting. So you go through this procedure. So the question whether 368 could have been used or not is a separate issue. And had that been used, we'd have had another argument here. But a derivative power derived from the Constitution and subject to the limitations imposed by the Constitution. No provision of the Constitution framed in exercise of plenary lawmaking power can be ultra-virus because there is no touchstone outside the Constitution by which the validity of provisions of the Constitution can be adjudged. The power for amendment cannot be equated with such power of framing the Constitution. The amending power has to be within the Constitution and not outside it. Why? Because you are subject to the constraints of the Constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the Constitution, you have to follow then what the Constitution obliges you to do constitutionally. If 368 were available.
There's only one part in Dr. Ambedkar's statement is very prescient. Dr. Ambedkar postulates that a future Constituent Assembly may be a future Parliament itself.
Yes.
Says the future Parliament, if it met as a Constituent Assembly,
yes,
its members will be acting as partisans, seeking to carry out amendments to the Constitution to facilitate the passing of party measures which they fail to get through Parliament by reason of some article of the Constitution, which has acted an obstacle in their way.
This is the precise argument.
The Constituent Assembly and the future Parliament.
So this is the precise argument I'm making, is what Dr. Ambedkar said. That it is the parties' partisan political measures that are carried through in the process in the form of legislation or otherwise, which can't be done as far as which will be constrained by the provisions of the Constitution, but the Constituent Assembly doesn't have any such fetters. Section 92.
That we saw, Mr. Sibal. Yeah. That we saw, you read out Section 92.
That's right. No, but what's important is the date. On the 19th of June, a political party in coalition with another party which was in government withdrew support.
That is not in a list of dates?
Yes. Just kindly note that. It's in the proclamation.
19th of June 2018?
Yes, Mullahs. BJP withdrew support from PDF.
This is
PDP.
Before the serial number 57, no?
Yes. Yes.